What you're about to see is courtroom chaos in real time, cases collapsing, charges shifting, and decisions being made on the fly. Stay sharp, because in this courtroom, things change fast.
Court does call the case, People versus Matthew Wright.
If you're returning the court, people.
I'm sorry? Oh, okay.
Matthew Wright.
Thank you.
Sorry.
It's all right. What are we doing?
Your Honor, maybe approach me really quickly.
That's how you want to start my day?
Mm-hmm.
Fine. Fine. You're not asking. Jerry says I'm not asking. Yeah, come on. All right. Record to reflect at a bench conference.
Your Honor, this is an executive preliminary exam. I did explain to counsel that it appears we are not able to proceed at this time. We anticipate that we may be able to, once we can get a hold of the defendant witness in this matter.
And just like that, the case is dismissed. Why? No witness. In criminal law, if the prosecution can't move forward with evidence or testimony, the entire case can fall apart instantly. But here's the twist. That doesn't always mean it's over for good.
And we will be authorizing the case promptly as soon as
Hmm?
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is on defendant's motion. Thank you. Court does call the case, People versus Leon Booker.
Amazon on behalf of the people, Your Honor.
Oh yeah, hours ago. But don't worry about it. No, I thought you were here all day. Yes, it has, Mr. Thank you.
Your Honor, at this time, people are people are unable to proceed as to count one. I would ask the court to remand count two to district court.
The brandishing in public.
Correct, Your Honor.
All right. So I'll dismiss count one.
Notice what just happened. One charge dropped, another moves forward. This is strategy in action. Prosecutors often narrow cases down to what they believe they can actually prove in court.
Maintain the plea of not guilty to count two. And this matter will be set for pretrial 1482 District Court on
April 30th at 9 a.m. before Judge Barr.
April 30th, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
All right. Thank you. And we'll continue. Court does call the case, People versus Demetrios Master.
Amazon on
Why are you
behalf of the
laughing?
people, Your Honor.
Your Honor, Joseph, on behalf of defendant, state your name.
Demetrios Master.
Okay, I got everything but one syllable in there. I was close. All right.
Your Honor, today's the date and time set for preliminary examination. At this time, I would ask the court to amend count one to make an attempt interfering with electronic communications. And then we would ask the court to remand on counts 1 through 4 to district court.
Okay, I'm not going to be able to do it that way. I have.
Now this is where things get technical. The court can't just tweak charges casually. There's a process. Charges may need to be dismissed and refiled in a different form to legally stick. It's not just paperwork, it's procedure.
Yeah, because what has to happen is count one would be dismissed. And then he would go down to on counts 2, 3, 4, and 5, which would become the attempt. I'm going to need the PAC code on that one. It's likely going to be 75545A with a bracketed A.
Correct, Your Honor.
Does Simon any objection to that?
No, Your Honor, thank you.
I would order that the people are to file an amended complaint in the case so that everything is clear.
We'll get that out there.
And as to count 5, your client is standing mute to that charge.
Thank you, Your Honor. Yes.
And the court will enter a not guilty plea, maintain his not guilty pleas to counts 2, 3, and 4. Count 1 is dismissed. I will set a pretrial before Judge Freshour, April 24th, 2025, 10 a.m.
Your Honor, can I ask a quick question? Is that here?
Yes, it would have to be. It's here.
Right. That would be greatly preferred. It's a DV. She likes to hurry the DV docket, but this is a client who's already been to court, been admonished on his bond condition. That's what she likes to do, and I'm not criticizing that. I'm just stating it factually.
So May 6th, 10 a.m. before Judge Freshour.
Thank you.
Bond will continue. Court does call the case of the People versus Derek Graham.
And is that on behalf of the people, Your Honor?
All
During
two.
on behalf of the defendant, both matters. Yeah, Your
Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, as case 24 FB 1431, the people are unable to proceed as to count one, as that count 2 be remanded to district court. And in case 25 FB 1109, people would ask the court to add count 2 of misdemeanor stalking. The PAC code 750.411H, and we are unable to proceed as to count 1, would ask that count 2 be remanded to district court.
Your Honor, with regard to, and apparently I have the case numbers reversed, but it doesn't really matter at this point. In both matters, Your Honor, I ask that the felony charges, count 1 in both files, be dismissed.
All right. In the case ending in 1431, that'd be the easiest one for me to do. I will indicate count 1 is dismissed, continuous plea to count 2 of not guilty. I'll set a pretrial in that matter at 14B for. Before I give you a date on that, let me.
We're gonna ask the court for bond on that matter, Your Honor, so if you could just take care of the other matter, we can address both cases.
All right. And so dismiss count 1. You're adding misdemeanor stalking.
Correct, Your Honor.
In the PAC code on that.
750.411. It's 1 year, $1,000 fine, 5 years probation.
Just 411.
Correct.
All right. 1 year, 5 years probation.
I'm sorry, Your Honor, my client was asking me a question.
No, it's okay. And so you waive any further formal reading of that and are not guilty pleas to that. All right. Count 1 in that case is dismissed. I'll set pretrial in these matters. All right. In both cases, pretrial will be set April 28, 2025, 9 a.m. before Judge Washington. And as to bond, Mr.
Your Honor, bond was, and I apologize because I forgot to look and see what the bonds are in these matters, but whatever they are, they were set obviously at a time when Mr. Graham had felony charges pending. Those 2 felony charges have now been dismissed. Mr. Graham understands that if the court does allow him to be released, whether it's on a PR bond or a low cash bond, that if he violates bond in any way, those matters could be reinstated. And I'm sure Mr. Graham does not want that to happen because today is a step forward with those cases dismissed. Your Honor, I'll have to ask Mr. Graham, the address I have for him is a Detroit address because that's who contacted me to represent Mr. Graham. I'm sure the court is going to ask if he's released, where he would be staying. And I would ask if the court would consider a PR bond with a GPS tether, no contact, no go-to. I think it would be appropriate in this situation.
I have, just speaking of addresses, I have a Miami Avenue in Ipsy.
Sorry?
Miami Avenue in Ipsy.
That would be his home address, Your Honor. I just didn't know what the alleged victim was also at that address.
Pay very close attention here. This just shifted from paperwork to real danger. We're now hearing explicit threats involving violence in children. This is exactly the kind of detail that heavily influences bond decisions.
Well,
She's not.
my no go-to is for Dakota Avenue, so I don't, is that,
That's
That-
correct, Your Honor.
all right, okay. All right, so people's response.
Your Honor, we would object to any modification about, we were in contact with the victim as recently as Friday, and she was on board the prosecution. We haven't heard from her today, and we have great concerns as to that aspect. But also in this case, we have great concerns given the threats that the defendant was sending to the victim, including threats to shoot her, to kill her, kill one of her kids, saying things, I'm about to kill one of your kids, bitch. As soon as I get my money and buy me a gun, I swear to God. And then the other case, saying things along the same lines of wanting to kill her kids. I swear to God, I'm going to shoot up in that bitch. I'm going to hit one of them bitches in the head. I'm going to catch one of your kids and I'm going to mark their ass. I don't care about going to prison. I can't wait to catch some of your kids. I'm going to kill you in broad ass daylight. So I have great concerns given the nature of these threats and given that we have not had contact with the victim today, but she did recently on Friday and that she was on board. We have great concerns. And I also believe he has a hold out of Jackson County for child support as well, Your Honor.
If that's the case, I was unaware of that part. The part about Jackson, that could be addressed if he's released on bond from here. Your Honor, with regard to the threats, I know this court knows it's not unusual in a case of this type for the people to have contact with the witnesses or victims a day or two before when they don't show. This is certainly not the first time that's happened. But all I can tell you, Judge, is something happened to the victim between last Friday and today. It wasn't my client, because he's been sitting in the Washtenaw County Jail. Yes, he may have made some threats. I can't dispute that because I'm assuming those were taken from jail calls. But yeah, when someone's sitting in jail, particularly at the beginning, they get upset. I understand that, but obviously no one's been killed that we know of.
And Your Honor, these threats were from the police report, not from jail calls. They were
Okay,
from
sorry.
what he sent the victim's phone that led to the charges.
So he was out. He was not in custody when he allegedly made these threats, and nothing happened to anybody. So Mr. Graham doesn't get insulted. Was running his mouth, right?
When he's out, is he working? Or,
Well, he's been in custody for a while, Your Honor, I assume. So I don't know the answer to that question.
got it.
Charge set up for April 1st, and I said it on this misdemeanor, and they had that prosecutor was Woods, and it was addressed, so it should have been a problem. But I had a job, I was supposed to start April 1st.